Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and I hope you're having a good day. For today's story, we are going to look at the recent filings with respect to the Take Care of Maya trial, which I wasn't expecting to do for an hour and 15 minutes. And then I was like, yeah, an hour 15 works, and Recovery Addict was like, how about now? Now also works, but I don't have the documents yet. So you guys get to watch me faff around behind the scenes while I, download the things and open them and make them look nice in the browser. But on the plus side, for all you Recovery Addict fans who are joining me, you may notice some improved quality in the audio since last time you dropped by. And the last time you guys were here, I just got my new microphone and hadn't done any filtering on it. And as some of you guys may have noticed, I'm sure, there were some problems like clicking noises and reverb and all kinds of issues because I hadn't done any filtering. Well, since then, I have done many things to further modify the audio. So now no reverb, no clicking, no distorting. You won't hear my setup. You won't hear my fans on my computer when it goes silent. All kinds of stuff. We really dialed in the audio to bring you the quality. So just want to let you know, I'm here. I'm working on things. And so now you don't have to deal with the distracting audio. So great. All right, I have the motion to compel sanctions. So I got that. And where is the other one? Oh, Lord. Are we live? We are very much live. I hope we're live or we're having problems. And I'm waiting for the other document at the moment. The white, red, black box, whatever thing. So hopefully that'll come through in a minute and we can cover that. Where's the hat? Well, I was wearing my earphones to listen to Recovery Addict and also listen to earlier today I was doing Colorado Supreme Court. If you guys like that kind of thing, Trump was arguing, well, his lawyers were more properly, but they were arguing about his ability to get access to the ballot. Colorado, or some people sued in Colorado to kick him off the ballot using the Section 3 of the 14th Amendment. And the Colorado Supreme Court had oral arguments on that today, and we covered that oral argument. And so that was exciting and fun for those of you guys who love the deep dive. So, plus one hat. All right, we'll deal with the motions to compel first. That's fine. That makes reasonable sense. All right, we'll deal with the motion to compel for sanctions. Give me a second to make it look pretty. This is what happens when you do it live with no prep. Fun times. All right, now I have to change this so it looks pretty. Do this, and I have to readjust my margins so it will actually show up on screen. I have to make the box the right size on the page. And I have to do that, do this other thing. It's not cooperating with me. There we go. Great. We are in the case of Jack Kowalski versus Johns Hopkins All Children's Hospital with a plaintiff's motion supplement for sanctions. Exciting. Now, I will say this as a general proposition. I have been frustrated as I have learned more and more about this case from you guys, about the judge and their lack of having control over the courtroom. For example, you guys told me it took 15 hearings to get access to the iCloud data. It should take exactly one. It should take exactly one. You send me a motion for discovery. You say, I want access to X. If I have legal basis to say no, I say no, back. Now we go to court, right? Motion to compel, right? Motion to compel. Great. So now we go to court and you say why you want the documents. I say why you shouldn't have the documents. We have a hearing about it. We bring in the relevant law and the judge just makes a decision. right? And then I, being a good officer of the court, follow the decision, or if I'm really PO'd, maybe I try to appeal somehow, but probably not on a discovery order. Probably can't get an interlocutory. So I just follow the decision and live with it. And if, that doesn't happen, the next thing that should occur, right, if I still say no, I'm not giving you the document, the next thing the other side would do is file a motion for sanctions because, I didn't do the thing. I'd probably get an order from the court, a notice to show cause why we shouldn't sanction you. And then I go to court to say why it's really okay I didn't obey the court order. And then the court gets out the whacking stick. That's what should happen. But apparently this judge is like, how about we just do it 15 times? It's okay that they didn't do the first 13 times. Let's do a 14th hearing. So this judge seems reluctant to break out the whacking stick, and it's very frustrating to me. I don't like judges who don't have good control of their courtroom. It tends to piss me off. All right. This is plaintiff's motion to compel supplement for sanctions, which we're probably not going to get because we haven't gotten them thus far, even though we really should have long ago. But let's read this. Plaintiff Jack Kowalski files this motion and states the following. On November the 2nd of 2023, this court instructed defendant's counsel to produce by the end of the day at noon. See, that sounds suspiciously to me like an order. That sounds suspiciously to me like an order, not optional. Hey, Johns Hopkins, turn over the IJ. No is not an acceptable answer. Hey, Johns Hopkins, turn over the iCloud data. No. No is not an acceptable answer. There should be an order to show cause. There should be the whacking stick. The court instructed defendant to produce by next day at noon and all documents with a scintilla of odor related to the Joint Commission, and any and all documents related to the run-up of the finding or classification of the immediate jeopardy. Not for nothing, by the way, of course, but court orders don't count if you're not going to enforce them. Much like, by the way, as I'm sure you've heard the classic parenting advice, don't threaten your children with something you're not prepared to follow through with. Because if they call your bluff and you're bluffing, yeah. So much like a parent must be willing to stand behind their threats to their child, a court must be willing to stand behind their threats to the attorneys, or they don't really matter much. And if you get whacked with the whacking stick, that tends to leave a mark and you learn fast. And if they don't do that, then you just are like, well, I can get away with anything because the judge's not going to stop me. Ha ha ha. On November 2nd, 2023, plaintiff filed their notice of taking deposition Dukas Tatum, which just means bring shit. That's all that means. Notice of deposition is bring you. Dukas Tatum is bring the documents, bring stuff. Of Angie Green requesting the documents. On November 3rd, Green appeared for deposition with counsel. Plaintiff counsel left the deposition with an 8-inch stack of documents that had not been previously produced despite court order. Where is the whacking stick? And, not for nothing, by the way, but those whacking stick penalties can get more and more severe as the judge gets more and more irritated with you. The first time the judge hits you with a whacking stick, it tends to be fairly minor because we're really hoping that, by showing you we're serious and are willing to do this, you'll stop. So it tends to be a fairly minor sanction. The second time you don't obey the whacking stick, it tends to escalate more because apparently you didn't learn the first time. And as the disobedience continues to grow, the sanctions tend to include more severe things than just money. The sanctions can include things like, how about you don't get to present that witness? How about you don't get to present your witness just because I'm mad with you? How about you don't get to present that argument just because I'm mad with you? Or the ultimate sanction in civil cases, how about you just lose? How about you just lose? That's a thing you can do in civil cases. You can enter a judgment against the party because they effed around and find out. How about that? Yeah, so, there's that. Okay, yeah. The weekend following the, okay, we read that part. On November 6th, defense counsel brought 2 boxes of documents to the courthouse. However, as rebuttal testimony produced and jury instructions were read to the court, plaintiff counsel did not have adequate time to inspect the documents. Well, no shit, because they dropped it on you at the last minute because, they're playing super dirty. And the judge should be, doing something about that. Play nice with others, your parent might say. Play nice with others, and if you can't play nice, you're getting grounded. Facts. So, plaintiff counsel requested defense counsel make the 2 boxes available for inspection at the courthouse. Yeah. Plaintiff counsel explained this issue to the court before the jury was sent back to deliberate. In response, defense counsel said he not checked his email that morning, but would as soon as the jury was instructed to deliberate that morning. Yeah, I find that difficult to believe. Because of their many apparent issues along the way. I'd be saying as a judge, can't help noticing your credibility seems somewhat in question to me at this point. So I'm somewhat disinclined to believe your representations to me as an officer of the court because you've sort of been playing dirty and or lying to me, and so I'm not inclined to believe you about stuff anymore. In response, plaintiff counsel informed defense counsel they wanted to see what existed that was subject to the court's order and admonished to produce everything. Defense counsel stated the boxes could be at the courtroom by 1. The jury returned a verdict shortly after 1, and again, plaintiff's counsel did not have time to inspect the documents. After the verdict was read, the court shifted to hearing final argument on the jury instructions and verdict form for the punitive damage phase, as well as evidentiary arguments and admission of documents they had marked for the punitive damage phase. Yep, they sure did. Like, yeah, what are the final rules? What are the final instructions? By the way, what additional evidence do you want to bring in, for this additional phase? And so we had a discussion. Then they said what stuff they want to bring in. And Johns Hopkins won some of those. And Maya won some of those. No one got exactly what they want because, that tends to be what happens. No one gets what they want. Everyone walks out a little sad. On November the 21st, plaintiff's counsel emailed defendant counsel requesting a Dropbox links and requested they produce the documents within 10 days, which certainly they did, right? On December the 1st, plaintiff counsel followed up to the request as the documents had not been provided. Shortly after, defendant's counsel responded and asked, what's the point of this at this time? Well, the point of it, as best as I can understand, is, court order. So, yeah, there's that. Yeah. Undersigned counsel responded and informed defense counsel that the court ordered all the documents multiple times. Again, see, this is where I'm going to fault Judge Carroll. I know some of you guys love Judge Carroll and you like the way he presides on the bench, and I totally understand that. I get it. But, I have to be a critic where I need to be. Judge Carroll apparently is a weak judge. Judge Carroll apparently issues orders and then doesn't, follow up on them. There shouldn't need to be multiple orders. There should be one order. One. After one hearing. One. And then the next thing that happens is the opposing side says, hey, they haven't followed your order. And then the judge issues show cause. You show up to the hearing and the judge beats you with the whacking stick. So I think to be honest, some of Johns Hopkins' behavior in court and some of their shittiness, not all of it. Johns Hopkins has some underlying shittiness, to be sure. But some of their shittiness in court, I think, is due to the judge. Because this judge will never stop you. And so Johns Hopkins has been given permission to get shittier and shittier and shittier because the judge isn't there to back anything up. So the judge is actually responsible for some of this shittiness against Maya. So, yeah. Defendant's continued failure to produce court-ordered documents solidifies the position in its motion for sanction, and plaintiff has and continue to be prejudiced by the refusal. Also, it's a court order. So do the thing. In fashioning an appropriate response, the court is guided by 6 factors. Whether the attorney disobedience was willful, deliberate, or contenuous rather than act of neglect. Well, after multiple motions, which somehow exist for some reason, yeah, I think, intent to defy seems proved. Whether the attorney has previously been sanctioned, apparently not, because, they continue to be shitty. Whether the client was personally involved in the act of disobedience. Whether the delay prejudiced the opposing party through undue expense, loss of evidence, or other fashion. Whether the attorney offered reasonable justification for noncompliance. I'm willing to entertain that in a show cause order. If I were a judge, I'd be willing to entertain that. Hey, why couldn't you produce the documents, or why didn't you produce the documents the opposing side like ordered? Well, I'm really sorry, Your Honor, but, my wife went into labor. There was a hurricane, tornado. There was a bomb scare at our office. There was an earthquake. So I had a desperate medical appointment that could not be rescheduled. Oh, okay. Those sound like good reasons. All right. Well, how much time do you need? I need another 3 days. Okay, fine. So, yeah, do you have a reason that makes, sense? Or are you just being a jackass? Yeah. The reason I'm Johns Hopkins and I don't want to is not going to do it. The factors are easily satisfied here. Yeah. But the 4th factor involves consideration of prejudice. Defendants continue to fail to produce the requested documents, prevents plaintiff from demonstrating the degree to which they're prejudiced. Also, you defied a court order. Plaintiff believes they're materially prejudiced and being prohibited from putting on materially relevant evidence that should have been admitted at rebuttal and punitive damages. But plaintiffs have no way to demonstrate the withheld damages contain material that would be helpful. Breach. I don't know why the IJ wasn't produced long ago. That there would be increasing sanctions. Hey, have you produced the IJ yet? No. $500. Hey, have you produced the IJ yet? No. $1,000. Hey, have you produced the IJ yet? No. $2,000. $5,000. $10,000. How about you lose? Plaintiffs also fear destruction or loss of 2 documents. No. I mean, it's not like we have any sort of evidence that in any way suggests that Johns Hopkins might possibly have been destroying evidence along the way. There's nothing in the record that indicates Johns Hopkins has, once they've been aware of the lawsuit, made choices that somewhat conveniently resulted in the evidence being lost. That evidence was lost through no fault of Johns Hopkins of their own whatsoever, and there's no reason that we should think that Johns Hopkins would fear that plaintiff should fear the destruction of these 2 boxes, because all those disappearing cell phones and cloud data and the IJ itself and all the rest of it, man, oh man, what are the odds? My dog ate my homework 20 times. What unfortunate luck by Johns Hopkins. On more than one occasion, this court admonished defendants' counsel for its failure to produce documents. That ain't enough. You need to break out the stick. Where is the whacking stick? Do the thing or I will beat you in legal language. As of the date of this filing, counsel has still not received a response and has not received the dropout links. No shit, you haven't received it. Defendant's original withholding and continued defiance not only prejudiced the plaintiff's ability, but is impeding the court's review, also making the court kind of look weak and foolish and not in control of their courtroom and not willing to, actually have some actual balls. Judge balls. Wherefore, we ask for a motion compelling production, which apparently we've already done many times, and we want some sanctions, which we will absolutely not get in any way because we haven't gone it this far. You think it wasn't to give fodder for appeal? No. 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 There are rules on this, obviously. There are rules on this. The trial judge just can't, do whatever they want. But judges are allowed to, control their courtroom and are allowed to give orders and are required that those orders be followed. It's called contempt, don't you know? Yeah. So, yeah. Do I think it was to strain appeal? No. Because, the judge, what you basically do is you start small, and you escalate and you escalate and you escalate and you increase damages, and then you say, how about you lose? And yeah, so do I think it was to stop an appeal? No. Because I think, based on my understanding of the record, as limited as it is, based on my understanding of the record, if the judge had said, how about you lose, I think the appeal court would probably uphold that decision. Because, Johns Hopkins went somewhat out of its way to F around. Fantastic. All right, I need the other document. I still don't have it. Where is this red and black thing so I can comment about that? I still don't have it in my email. Is it in my Discord? I don't have this other red and black email. Who has it? Who has the document? Who has the thing that Recovery Addict was looking at? I need it. I don't have it. Kurt at Uncivil Law LLC. Please send me the document so I can comment on it. I understand Johns Hopkins filed it, so I'll probably have some snarky things to say, one would imagine. Jules said she was going to send it to me, but not so much. What is red and black? Something about some documents or something. I don't even know what it is. Did I check my spam folder? Let me see. It's a good question. It is not in my spam folder. It's the battered and bruised box. Yeah, whatever. I just need the document so I can review it. Since I've got 1,000 of you here. He sent you by text? You might be right. He did send to me by text. Thank you for reminding me. He did. You are correct. Thank you for reminding me. You are a good person. Let's see now. How do I actually deal with this? Okay. I need to email this to myself somehow. Hold on. Talk amongst yourselves. Forward to myself. Send it to myself. Fantastic. Jules finally sent it to me as well. I love you, Jules. Jules, you're great. All right. Let's see. We all love Notorious. Notorious is fantastic. Notorious. 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 Jules. She's the Notorious. Okay. Let us read the other document. The objections to production of the black and blue documents, Joint Commission documents. Oh, Lord. By Johns Hopkins. Okay. Let's read this. Defendant Johns Hopkins, All Children's Hospital, by and through undersigned counsel, states it's in the process of reviewing and preparing production of certain documents pertaining to the Joint Commission and reviews of the defendant in late 2018 and 2019. Defendant states it objects in general to production of these documents, as much as the same are completely irrelevant to the above-styled cause, particularly in post-trial proceedings, and such are beyond the scope of permissible discovery. Well, that's an interesting idea. That's an interesting idea. We stalled on it so long, we defied the court order so long, it's effectively become moot. Those would have only been valuable during, the punitive phase, and that phase, of course, is well over. So it's become moot that we didn't obey your order. Let me just help you out here. If you could obviously file a motion to reconsider my order in lightness of mootness, but if you file, like, I just object after I gave you an order as a judge, whacking stick time, whacking stick. Defendant incorporates in reference in this regard its supplemental disclosure and motion for clarification, which basically was like give them everything, and motion for sanctions and cross motions with respect thereto. Amazingly enough, this is not the first time we're doing this. Defendant further states that such productions as it indulges. What? 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 Mind blown. Mind absolutely blown. I lack words. Defendant further states that such production as it indulges. It's an indulgence. It's a gratuity. It's a courtesy. It's our just out of a spirit of our ability to want to play fair. Wow. That word choice is so, I don't even know where to start. Okay, not that I should really need to point this out to people, but this isn't a matter of indulgence. In any sense at all, ever. There is no sense in which this is an indulgence. All right. One side sends to the other a request for discovery. Okay. If you think it's illegal or not proper in some part, you can object and say, well, no, I don't want to do that because I think this, you could say, well, I think the scope of your inquiry is too wide. You could come up with all potential kinds of objections depending on it. And then typically what happens at that point, by the way, typically what normally happens in a normal case is normally at that time, the attorneys will talk to each other like human beings and try to, reconcile it out. It's like, okay, what can we, do to make you happy? And there will be some discussion, and sometimes there will be an accord. Okay. If that can't happen for whatever reason, then we go to court. Right. And by the way, judges typically hate refereeing discovery fights. As a general rule, judges really hate doing this because it's like, dude, come on. You guys should play nice together. I really shouldn't have to come in and solve this stuff. We're in a preliminary stage. You all know the rules. I really shouldn't be here. Why am I here? Why are you making me do this? This is so typically with many judges, just the very filing of the motion to compel will kind of make them irritated. But regardless of that, you go to court and you argue about it for a while, and then the judge, makes a decision, and then that's the decision. And, there's an order. So either you do it because you comply with the rules and the law, or if you think, that you shouldn't comply with it because you think that this is not within the rules of law, then you say no. You either discuss it or you go fight about it in court. The judge makes an order, and that's the end of the game. To call this an indulgence is so insulting, is so insulting to the court. And I think is reflection about how Johns Hopkins perceives the court, largely a fault of the court's own making. But reading this to me, it's like, what do you say? What do you mean indulges? Indulges. Like it's just by our grace and our it's just by our grace and our desire to cooperate that we have, done this. Yeah, okay. KL Burke gives 20 gift memberships. Thank you very much for supporting the uncivilians. We do appreciate it. So apparently they state that the production as they indulge, notwithstanding the objection, is strictly subject to the court's previous confidentiality order. Okay. And the material produced must be reviewed and then promptly returned. Okay. If it's a confidentiality order, then, fine. In addition, the following information documents from the box made available during trial is objected to on the basis stated, each having reference to the item number attached here too. Okay. Item number 4, J. Hatch Cardiac Surgery Quality Review Summary. Made in anticipation of litigation. Okay. Work product attorney client prepared in anticipation of trial. Also peer review privilege. I don't know Florida law that well. So, as well as patient safety review committee privilege. Is that a thing? Patient safety review committee privilege? Okay. Maybe there's something there in medicine I don't know. But, all right. 5, same thing. 32, objection subject to the peer review committee privilege pursuant to law. Peer review committee. 68, the objection on the basis document contains substantial non-party patient information. Couldn't you redact it out? It's like, we can't obviously disclose anything as it relates to other patients. So, we redacted all that stuff. So we didn't disclose any other patient's information. No? Can you do that? No? Disclosure of which would violate privacy rights and third-party law under HIPAA and Florida law. I'm somewhat doubtful about that, by the way, in the first instance, because HIPAA, of course, makes provisions for court orders, as you would expect. So I'm not sure this necessarily is covered by HIPAA either, but even if it was, can't we redact out the information? But we just object to disclosing the entire thing. Yeah. Patient names are redacted and all files given a number. Well, maybe they're not redacted on this one. I don't know. Okay. Look, in chat, Georgina says, I worked in medical research for 30 years. Patient names are redacted and all files are given a number. Okay. Georgina, what do you think is the probability that Johns Hopkins doesn't follow that practice? What do you think is the probability that they don't do that and don't redact the names and just put them in the plain and open in all their filings for all to see? What do you think is the probability that Johns Hopkins medical keeping practice is perhaps non-conformity with best standards of the medical community? All right, 70, substantial non-party, same issue. 71, non-party, same issue. 73, same thing. 74, same thing. 76, same thing. 164, object subject to peer review committee privilege. I'm half tempted to look this up by the end of the stream, depending on where we are, because I'm interested in what it has to say. There's some special Florida thing here. I'd like to know about it. Objection pursuant to law, work product, attorney produced anticipation of trial. Was it though? Was it produced specifically in anticipation of trial? Or is it something you would normally do anyway? I, as a judge, would be getting incredibly annoyed. If I ever become a judge, it should be pretty entertaining to watch, because I feel like my feelings will be more manifest than Judge Carroll. $290, same thing. $298. Do we have anything new? Review privilege, HIPAA, produced in litigation, blah, 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 blah. And more stuff and more bullshit and more stuff and more bullshit. And we say it is produced, the materials produced during trial, and has produced hundreds of pages of other material. This court intra-trial order subject to objections and which remain at time of trial. And then we have the inventory of the blue box with all the wonderful things the blue box contains. Note, apparently, by the way, they did not turn over the other items in the blue box. They didn't object to literally everything. They objected to some things. So, you know what, as a lawyer, you do at that point? You produce the stuff that you don't have an objection to. Because, order. So why didn't they produce the stuff that wasn't subject to an order? So here's a full documentation of all the things that, Maya can't have access to. For some reason. And here's the inventory of the black box. I feel bruised. You guys were saying these are the bruised boxes. I feel bruised. I feel offended on a professional level. I've never had to deal with someone like Johns Hopkins. Like, even obstinate people. Like, this is a whole new level. This is just so offensive to me. Of course, my field was patent law, so there is something of that. So the practice areas are very different, but still. And some more documentation and more documentation and blah, blah, blah. And here's all the things we didn't turn over. Okay, seeing as there's plenty of time left in this stream, because these documents were just logs and inventory and not much content, let us go read the Florida law to see the degree to which they are actually making good legal arguments. Because, I'm always open to the possibility that Johns Hopkins might make a valid legal argument. I've before pointed out areas where I thought that maybe they had good legal arguments. So let us read this law and see how interesting it is for whatever. So they cite 2 Florida laws. We can go read Florida law. We understand how to go read and interpret law. I'm a competent lawyer. I don't know this law, but I do know how to read. And so let's read it and see what it has to say and see how much bullshit is involved, because I'm betting it's some. All right, Florida law 766.101. I'm going to call it Florida law because that entertains me. All right, so let's see. Florida statutes. Here we go. That's what I need. Oh my God. Apparently that website was infected, so that's nice. 7661. Okay. So we can get it from the Florida government. So this is 766101. Okay. Let's take a look at this and see the degree to which it speaks on the issue. Let's see. Properties. Change to the website of the Florida Senate. Thank you. Can we make it a little bigger so people can read it? That'd be nice. Just the margins. All right. Let's take a look and see if they're quoting it accurately. All right, we turn our attention to, this is 2012 statutes. Is this the current statute? Okay, hold on. Laws, statute 23. So we need 766, torts, and we need medical malpractice, and we need section 101. Great. We'll look at the 2023 version. All right, as used by this section, the term medical review committee means a committee of a hospital or surgical center or health maintenance organization. So I assume that they have such a committee. A committee of physician, hospital, organization, provider, or integrated delivery. A committee of state or local persons. Okay, so let's just assume that they're a medical review committee and move on with our lives for the moment. So, all right. So they further define some things. Okay. So they say a medical review committee of a hospital or ambulatory surgery center or health maintenance organization shall screen, evaluate, and review professional and medical competence of applicants to and members of staff as the conditions of licensure. Each healthcare provider shall cooperate with a review of a professional competence performed by the medical review committee. Okay. Section 3A. There shall be no monetary liability on the part of, and no cause of action for damages shall arise from, any member of the duly appointed medical review committee or any healthcare provider furnishing any information, including information concerning the prescribing of substances listed within a section, to the committee. All right, so you can't sue members of the committee, and you can't sue the provider with respect to furnishing information to the committee, including a person acting as a witness, incident reporter, or investigator to a medical committee for any act or proceeding undertaken or performed within the scope of sections of the committee if the maintenance organization acts without intentional fraud, which arguably potentially happened here, but never mind. And then they say the provisions of this section do not affect the official immunity of an officer or employee of the corporation. Okay. So I don't think this section applies, amazingly enough. So this is essentially, for lack of a better description to make it somewhat analogous, this is essentially equivalent to making the report. Well, it's analogous, not equivalent. It's analogous to making a report to child services, right? You can't sue the child services person, and you can't sue the person for giving information to the child services person, right? It's a protected communication because we want people to be able to speak freely in making these kinds of official reports so that, they don't have to fear about, being sued because they supplied information potentially on, scant evidence, because a doctor might reasonably make a report on the basis of very little, depending on the circumstances, obviously. But you could imagine a circumstance in which a doctor might make a report to child services that would be reasonable without much actual objective evidence. So it's like, I can't really point to anything in particular, but, there's something here, and I will tell you what limited I know. And so you can't sue them for that, and you can't sue the child services. So this is sort of similar in that respect. Okay, you can't sue the committee, and you can't sue anyone for giving information to the committee. Okay? But that doesn't protect the information itself, right, to the extent that it exists outside of and wasn't just generated for the committee. So to the extent the information exists in some external record that already exists, then the submission of it, you can't sue for giving the information, but you can still get the information itself. This is not a privilege in the sense of I don't have to turn over the information. This is simply I can't sue you for turning over the information, which is not the same thing. So I think this is misreading the statute as far as I can understand it. Okay? And as a matter of policy, it makes sense, by the way, because you want doctors to be able to speak freely to the committee so that the committee is in a position to help improve the practice of medicine. You don't want to get into a situation where the doctor can't report something because it would hurt them. So you want the ability to speak to the committee so that, the information you're providing specifically to the committee is shielded. So if it exists outside the committee, then yes. If it only exists inside the committee, then no. So, and somehow I doubt that these reports exist only within the committee. So I press X to doubt on that one. So, except as provided, the section shall not be construed to confer immunity from liability on a professional society or hospital or any health professional while performing services other than as a member of the committee. So, if you do make a report to the committee or the medical bar, whatever they call themselves, can still sanction you, but you can't sue them. So they can discipline you, they can fire you, they can report it to, ethics for the Association of Doctors. They can strip you of your license, but you can't sue them. 5 is what's important good. The investigations, proceedings, and records of the committee, as described in the preceding subsections, shall not be subject to discovery. Okay, so section 5 is more important. Thank you, A. Henninger. The investigations, proceedings, and records of the committee, as described in the preceding subsections, shall not be subject to discovery or introduced in evidence in any civil or administrative action against a provider arising out of matters which are subject of the evaluation review of the committee, and no person who is in attendance at such a meeting shall be permitted or required to testify as to evidence or other matters produced or presented during the proceedings of the meeting. And then, this is what I was saying earlier. So even before I got to section 5, I knew this. So so that's just how good a lawyer I am. Even before I got to section 5, I was like, yeah, if it only exists within the committee, then sure. If it exists outside the committee, then not so much. And section 5 amazingly says exactly what I said. What are the odds? So if it's an investigation proceeding as described to the committee, then, not so much. But if the information, documents, or records arise from original sources, are not to be construed as immune, merely because they were presented. Facts. Nor shall any person who testifies before a committee or is a member prevent from testifying as a matter within or his knowledge, to the extent they exist outside the committee, but said witness cannot be asked about their testimony within the committee. So, yeah, as amazingly enough, again, to the extent that you're producing something specifically for the committee and just the committee, yes, it is protected, but I have my doubts that this is true in some of these things. So I'd probably want, some further information, especially because Johns Hopkins is not to be trusted. If they were normal lawyers, I'd probably take their word for it as a judge, but these guys have shown themselves to be somewhat less than reliable, so, Pat says they prevent Maya's doctor from seeing her. That isn't necessarily a problem, although it might be under state-specific law. I don't know specifically. But as a general proposition, doctors have to be licensed or admitted within the hospital system. So it isn't inherently a problem that they prevent Maya's doctor from seeing her, but maybe there's some state-specific law, so, your mileage will vary from state to state. But we still have one other section of law that they say is relevant to this, so let's try something else. They say 395.0193 is relevant. Okay, we can read that too. What is 395.0193? Let's see. 395 is public health. 395 is hospital licensing and regulation. And part 1 and point 0193. 395.0193. Okay. Let's turn our attention to Florida Statute 395.0193. Licensed facility, peer review, disciplinary powers, agency or partnership with physicians. It is the intent of the legislature that good faith participants in the process of investigating discipline shall, in addition to receiving immunity from retaliatory suits, to be protected from federal antitrust suits filed on the Federal Sherman Antitrust Act. Well, I'm all super thrilled and all, by the way, that Florida thinks that this should be protected from federal antitrust suits filed under the Sherman Act. But, the Sherman Act is a federal law. And amazingly enough, the state of Florida can say, the state of Florida can't say, we'd like you to have immunity under federal law. That's not a thing. That's not an option. Florida cannot say, hey, don't worry, you're immune from the federal Sherman Antitrust Act. No, That is not a thing. But Florida's going to try anyway. Each licensed facility, as a condition of licensure, shall provide for peer review of physicians who deliver health care. Each licensed facility can develop written binding procedures under which peer review could occur. Okay, so we do some peer review. That's nice. If a reasonable belief exists that a staff member or physician who delivers health care at a licensed facility may constitute one or more grounds for disciplines provided in the section, the peer review shall investigate and determine. The governing board, after considering recommendations, shall suspend, blah, 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 blah. So, amazingly enough, there is some internal process by which the hospital can suspend a doctor. Deep thoughts. Here are some reasons we can suspend them. Great. All right. Pursuant to law, any disciplinary action shall be reported in writing to the Division of Health Quality Assurance. The state would like to know about this because although you've dealt with it internally, maybe the medical board would like to take a look at it. The notification shall include what happened. All actions, if different from those were reported, shall be reported to 10 days within the division. So if they take additional action for some reason, then 10 days. Won't the plaintiffs need the files if defendants are asking for a new trial? There is no way on this earth they're going to get a new trial from this judge. And I don't really see that happening on appeal either. We only need a new trial if we need a new discovery as to facts or need to talk about facts. And I don't think the trial court really wants to do that. And I really seriously doubt the Court of Appeals wants to do that. They really don't want to do this for judicial economy. So they're probably, the odds of a new trial, in my humble opinion, are kind of low. Not for least of reasons, but Judge Carroll made decisions, much to the protests of Johns Hopkins, that helped to preserve options for the Court of Appeals. So in the event that the Court of Appeals needs to strike a cause of action or reduce the dollar amounts, then they know what to do because they know exactly what the jury did and they know exactly how much they awarded for everything. So if they need to strike a cause of action or reduce the amounts, they know exactly what to do because Judge Carroll gave them all the information. What a smart judge. Appeal court will rescind it. I doubt it severely. I doubt it a lot. I don't think that's going to happen, but we'll see, I guess. Maybe you'll turn out to be right. There shall be no monetary liability, no cause of action against any staff or board. So again, you can't sue them for the actions they took as part of disciplining you internally. You might be able to get the decision overturned in some way, but you can't sue them. Fine. For a single incident, we have to do this, and then some other things, and then some fines. The proceedings and records. Okay, the proceedings and records of the peer review panels, committees, and governing boards, which relate solely to actions taken out in carrying this section, are not subject to inspection under the law. Solely. Yeah. All right. The investigations, proceeding, and records of the peer review panel committee of the hospital disciplinary board, blah, 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 as described in the section, shall not be subject to discovery or introduction of evidence arising out of it. And any person was there can't testify about it and blah, 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 blah. However, if the information, documents, or records are otherwise available from original source, are not to be construed as immune from discovery merely because they were presented to the board. So once again, anything that happens in the board stays in the board, legal style, but to the extent it exists outside of it, not so much. And again, I'm somewhat disinclined to take Johns Hopkins' word for it that these records exist merely because the committee was creating them. So, but in any event, this should have been dealt with by the court long ago. Right? This should have been dealt with the court long ago. They say, hey, give us the records. They say, we can't. Or we're not going to because they're privileged. Or we can't. HIPAA. Right? And so then typically you pick up the phone and, talk to each other. And then once again, if that doesn't happen, you go to the judge, motion to compel. Hey, judge, they won't give us the records. Well, we don't want to give them the records because they're privileged, because they were only created pursuant to this. And we also don't want to do them because of HIPAA. And the judge hears the arguments and the law, and they make a decision. Okay, do this. Okay, strike the HIPAA information, but include everything else. Okay, I want to review them. I want to review the records in camera, or I want to have some limited testimony, declarations, maybe from people that says it only existed in the committee and there's nothing that exists outside of the record. Maybe some sworn affidavits would be fine. And then the judge makes a decision. So the judge should have made this decision long ago. This should have been dealt with in the pretrial long ago. But we have to have the 15 hearings because this judge doesn't want to put their foot down. For whatever reason, they don't want to put down their foot. And so that's very annoying. Yeah. So, yeah. So I don't really like the lack of control in this judge's courtroom. A recent case where it looked like on the record the judge had good control of his courtroom was the one dealing with Sam Bankman-Fried in federal court. Obviously, there's no cameras in the courtroom, but based on the proceedings and notes that people took, it looked like this judge had lots of control over his courtroom, and I appreciate that. That judge was willing to make decisions. And then, he did that thing. And he's like, I already ruled, let's go. I'm like, wait. No, we're moving on. Choo-choo goes the train. Choo-choo goes the train. We're moving on. Choo-choo, I don't want to. You have to. No. Yeah, so, there's that. And then, if the judge abused their discretion or something, you can deal with that on appeal. But, of course, you have to find harmless error, and that would be pretty hard too. So it's like, even if you make a mistake as a judge, it has to be a mistake that matters. And given the amount of information against Johns Hopkins, I somehow doubt that if these records had been admitted, even assuming it was a mistake, it would be a mistake that matters. So there's that. But I don't really like the way the judge handled this. Yeah. So what else can we talk about since we have 1,000 of you here? There's not much to talk about here. I wouldn't get your hopes up. Look, guys, I know, like you're saying, if the judge doesn't do it at this point, I'll be surprised. Will you really be surprised if the judge doesn't do it at this point? He hasn't done it up to this point. He hasn't done it at any of the many, many, many times Johns Hopkins has effed around. Why would he do it now? What sanction could he possibly even give at this point? And what could he do at this point? He can't really do anything. I suppose he could say, well, I would, I suppose he could say, in the alternative to the jury's verdict, I also, in the alternative, issue a directed verdict against Johns Hopkins for effing around, so they could give Maya an additional win. So take your pick of appeal court. The jury found it, or they effed around so hard, I issued a directed verdict. That could be fun. But that doesn't seem like the kind of thing that this judge is going to do, so I wouldn't get your hopes up. But that's where we're sitting. Look like he's elected. Could he fear Jay Hatch's funding an opposer? I suppose, but, that's... First of all, I don't think Jay Hatch is particularly fond of him anyway, so I wouldn't put it past them. And second of all, a judge should have some big balls. Thank you for the super chat or thing you gave. I appreciate it. Let's see if I can open up my YouTube backend so I can read some. You gave Lynn Barry gifted 20 gift memberships, and Jasmine Braids gave 10 Canadian dollars. Thank you very much for your contributions to the channel. They make a difference. By the way, for those of you who have Twitch and have Amazon Prime, you can sync up your Twitch account with Amazon Prime, and I'll give you the instructions in chat right now how to do that. And you can subscribe on Twitch, which is the paid option, for free. Twitch is like YouTube. It's a streaming service, but it's typically used for gamers. But of course, other things happen on it. And now that Twitch allows it, I'm doing co-streaming. So if you have Amazon Prime, you can subscribe on Twitch for free. The instructions are in the bot gave you. You can support the channel, and we would really appreciate it. I think we were at 96 at last count. Our first goal was 100, so we're pretty close. So that'd be nice. And we also have the bot working now, for at least for the moment. So the YouTube comments go to Twitch, and the Twitch comments go to YouTube. As you can just see, the restream bot just told you what someone said on Twitch, and so the chats are combined. So that's nice. Ariel gets 5 gift members. Do I have Patreon? No, I have a locals, but I don't really use it. I would just as soon that you give me money through PayPal or something. I think you can set up monthly donations, incidentally, through PayPal and stuff like that. So no, I don't have a Patreon. I have problems with Patreon as a company, and I don't really want to do business with them. I have a locals, but I don't really use it, so yeah. Can I put the instructions in a community post? Okay. Scott, you got to make sure your account is set up to receive gifts, and it's not a branded account, so you might want to check into that. I had a nice little clip earlier today where I clipped out a segment of a live stream I did with Ian Runkle from Runkle the Bailey and Rob from Law and Lumber. I did a little clip of a live stream we did on Monday where I and Ian Runkle were a good team in slowly torturing Rob from Law and Lumber. Many lulls were occurring. You can enjoy that. I recommend checking it out. And we did a Supreme Court decision also yesterday. We did one on a Shen Hotels versus Lawfer, dealing with some issues on the Americans with Disability Act. And we did Trump today at the Colorado Supreme Court. And so we cover a lot of stuff. Where can you see that? On my channel, On Civil Law. It's all on my channel, at On Civil Law. You can see it in past streams, past content. Plenty of good stuff there. The Twitch Prime linking instructions. Here it goes again. Pretty short. Support us on Twitch with your Prime Gaming sub. Just connect your Amazon account at twitch.tv/settings/connections, then manage your subscription. That's cool. We have lots of great content on the channel. We've been streaming a lot lately, so it's been great. What happened with Nick and Sean? I don't know what you mean. If there's drama, I'm not aware of it. We currently have 98 subscribers on Twitch. We need 2 more to get to 100. There's got to be 2 more of you who have Amazon Prime and Twitch. Can I play the clip now so we can all watch it together? Sure, why not? That sounds fun. Thursday Night Thunderdome as well. Tomorrow we have Thursday Night Thunderdome where we do a weekly roundup of legal content, and it tends to be pretty fun. So I hope you will join us tomorrow evening at 7 p.m. Central. Rodana says, I appreciate you covering more political cases. I always just try to talk about the law, regardless of the politics. I just try to give a good legal analysis regardless. So, I have no problem covering it because it's like, well, just give you my legal opinion as best as one man can. Why not? That seems like a good thing to do, right? All right. So let me put this on screen. Okay. All right. This is. Hold on. Got it. All right. Now I need to change the audio so it will go through my headphones. Great. And put it on screen. All right. Let's watch this video where Ian and I slowly torture Rob. Just for some context, the document that we're reading is an attorney who's being disciplined by the bar because the attorney likes to go around in his car and throw out Pringle cans full of his own feces. This is apparently something he likes to do for fun and apparently stress relief. So let's read this. Let's listen to this excerpt from the thing. Rob, I think you're going to like this next paragraph. Can I read it?
It's kind of a bargain. Oh, yes, absolutely.
All right, Rob, you'll like this one. During his disciplinary hearing, Blakesley testified he engaged in similar misconduct on at least 10 other occasions that year, and he randomly chose the locations where he deposited the Pringle cans containing his feces. He also specifically denied having knowledge that the parking lot in question belonged to Haven and Hope when he threw the can from his vehicle. Apparently, this is just a thing that he does randomly.
So his defense is
recreational Pringles poop can. That's a new thing.
He just likes driving. He just likes driving around with Pringle cans full of poop and throwing them randomly around.
And this is his defense, right? He's saying, I'm not targeting the victim's advocate. I just happen to throw poop randomly. And I
need to ask the next logical question, or I don't know if it's a logical question, but why? Right? Assuming somehow he didn't know it was the center.
He says stress just relief.
Random. He said he does it for stress relief.
Mm-hmm.
And we couldn't think of any other methods to relieve stress.
Well, it's like Rob says, if you're feeling stressed, go make something. Rob makes pens. I make leatherwork.
That is what Rob says. That is what Rob says.
Number two.
Cannot be denied. Cannot be denied. It is.
Nope. Do not take my words and justifies Pringles pooping.
Rob approves of this. It is a arts and craft made by a loving maker who wants to just share his art and creations with the world for free, nonetheless. Rob.
Nope. That's not what I meant. I meant a lot of things. I didn't mean that. Nope.
I mean, of all the hobbies for this guy to take up, this is one of the weirdest. And I mean, there's some questions I have, at least, as to how he made this particular product. Did he open the empty Pringles can and just directly into it? Or
I wonder if he chose what to eat specifically
that
would influence the poop.
This is so bad.
As part of his artistic expression. I think today I'm feeling like Mexican. No, Japanese is more the way to go for this motion.
And there's Taco Bell, which would, I don't know that the Pringles can could hold Taco Bell.
So I'm like, is he fishing these things out of like the toilet to load them in there, or?
Nope, right in the can.
Well, I guess Pringles is probably not going to hire this guy to be a spokesperson.
One would assume.
I wonder if he used the same kind of Pringles. Was it always like the barbecue chip? Was it the same every time? Or did he pick the flavor of chip as part of the artistic milieu? Did he eat the chips to generate the poop that he pooped into the can?
I am so mad at you right now, Kurt. I'm so mad because this is making the artistic expression argument. Like, nope. This is just a jackass lawyer who was just being a jackass lawyer. Oh my God.
I hope he was avoiding spicy flavors.
Oh my God. That's so bad.
I'm here for the creative arguments.
Just like Oh my god, what if he had curry? What if he had curry?
Oh man, curry would be just like the problem is I don't know like how waterproof are these cans?
I
Um,
why are we here? Why is this where we are? We're,
because we're past 2 hours and we're talking
this
about a
is
guy who pooped into a Pringles
nope.
can.
This is no place. This is not a place. We don't.
So one of the issues that came up at this hearing was whether or not that this reflected on his ability to practice law, or whether this was something that was completely unrelated. And they note, we adopt the finding of misconduct and expressly find that his conduct adversely reflects on his fitness to practice law, even though that conduct is not expressly prohibited by another rule.
Of
Now,
course,
I
'cause
would have
he's
actually been,
shitting in a can.
I would have been
I
kind
know,
of startled if they did have an express prohibition against this.
I know of no rule against the shitting in a can, Rob. I remember reading that rule of ethics.
Also, KPT with a winning comment here.
Rob's pen is the wrong color for this.
That sort of brownie orange.
Mm,
We're about to get the finger.
mm.
Rob is annoyed. All right. Um. All right. So, was it?
Maybe Rob. Well, I can't believe I was going to say this, but let's go for it. I think Rob should put some poop in some epoxy and make a pen from that. I think that would be really good for the color is for the stuff.
So we
Rob,
are getting the
Rob,
finger here.
yeah. So yeah. So Ian and I, you roast the ones you love, as you say, and we roasted Rob, and it was great. Yeah. So we had jokes. We had jokes. Law and Lumber is members only in 30 minutes. I'm a member of Law and Lumber. Maybe I should redirect over there. That's courtesy to Rob. I don't know how many of you are members of Law and Lumber, so many of you may not be able to watch it, but if you can, it's good. But yeah, Rob's a cool guy. He's my friend. His membership is not as cheap as my membership, though. I think he charges $4.99. So I got the best membership game in town, man. And we did pass 100 Twitch subs while we've been streaming. We're at 102, by the way. We're at 102 subs with 928 followers. So we have passed our first goal for subscribers and are well on our way to passing our first goal for followers. So excellent. That's very good. So we are making progress, man. Rob is going to really go appreciate you reshowing that. Probably. I think it will please Rob. I think Rob will be very happy with me creating a clip of that and hosting on my channel, and also now showing it to the 900 of you who are here. I think Rob really will appreciate that and will do wonders for our relationship going forward. So that, yeah. Oh, Lord. What you can say to a friend is a little bit different than what you can say to a stranger, right? So, yeah. Send it to RA. Ew, if he's streaming, I'll be happy to send him back. That's cool. Yeah, if RA is streaming, I'll send it back his way. That would be a really nice thing to do. Although I am slightly mad at RA, but not in a way that's going to hurt us. But he, as you guys will remember, when I came in chat, he said, "Hey, are you going to cover this?" And I'm like, "I can." And he's like, "Well, I'm going to have a podcast in an hour 15. I'm like, "I said in chat, an hour 15 works great for me." So I scheduled it for an hour 15. And then he's like, "Well, we're going to sign off." I'm like, "Wait, what?" We're redirecting you to Kurt right now. Okay. Well, that wasn't what I thought the deal was, but all right. Yeah. So, yeah. Right. He's a good guy. I'm not mad. It's just like, I didn't have any time to prep at all. I had to faff around for a while. Is he streaming? Addict. It doesn't look like he is streaming. Oh, there he is. Not relevant episode. Okay, cool. I can send you over his way. All right, so I will send you over his way, and he just started just now, so you only missed 4 minutes of it. So kick ass. Please remember to give Recovery Addict my best. I do love him. Kestrel says it took the mods by surprise. Yeah, it didn't it? It took us all by surprise. It was fun times had by all. I've been Uncivil Law. Until later, my friends, I hope all's well. Cheers, my friends, and goodbye.